Hello and welcome to Insurance in Canada. I'm your host, Rick Pineda. Thank you so much for joining me. On today's episode, we're going to look at three stories, but all three of these stories involve court cases involving the insurance industry. Our first case, we're going to look at a broker that was brought to court in British Columbia due to a duty to follow up with the client regarding coverages that were declined. Second one involving insurance company and a contract dispute in the Northwest Territories. And our third story will take us back to British Columbia involving ICBC and injury suffered in an automobile accident. So without further ado, let's get on with insurance in the news. Our first story today comes from British Columbia involving a brokerage that was sued by their client. The client basically argued that the brokerage did not do a proper job in explaining coverage to them for a coverage that they declined that in the end they needed due to an accident that they suffered. So let's take a look at the case. So a client declines coverage, must brokers follow up with a recommendation to buy it? A broker explains an auto insurance product to a client. The client declines to buy the coverage. Does the broker then have a legal duty as an insurance advisor to follow up with a recommendation to purchase the coverage? Not necessarily. BC's Court of Appeal has ruled. At least not when the client has heard the product explained to them several times before and the client has shown no past or current interest in the coverage. I find that an auto plan insurance broker, an auto plan is the automobile insurance product offered by the Insurance Corporation of British Columbia, has a stringent duty to provide customers with information, counsel, and advice about all available insurance coverage to meet the customer's needs, including UMP or uninsured motorist protection. BC Court of Appeal Justice Christopher Grower wrote for a three-judge panel in a decision released August 12, 2025. So long as the customer adequately describes their situation, the broker must review the customer's insurance needs and provide the full coverage requested by the customer. However, that duty does not extend to go further and encourage customers to purchase excess UMP. This is particularly the case for customers who have a history of declining excess UMP in the past, who do not make any specific inquiries in response to the agent's explanation of excess UMP and give no sign of a failure to understand the concept of UMP. In Carrière de David versus Westland Insurance Group, a BC driver claimed his broker had a legal duty to follow up and recommend excess UMP coverage that he had declined. He was appealing a lower court decision that found a Westland broker had in fact explained the coverage to him in spite of his insistence that she had not. Whistler, BC resident Mark Carrière de David was riding as a passenger in a Pontiac Grand Am owned and driven by his then girlfriend in July 2016. They were traveling southbound on the Sea to Sky highway that connects Whistler to Vancouver, about 30 kilometers south of Squamish. The car rounded a curve in a 60-kilometer-hour speed zone. The driver oversteered, causing the Pontiac to spin into the northbound lane where it struck another vehicle, a Volkswagen Golf. As a result of the crash, Carrière de David was diagnosed with a severe traumatic brain injury as well as various bone fractures in his neck, spine, shoulder, chest, and pelvis. He also sprained his ankle and lacerated his kidney, liver, spleen, bowel, and colon. Wow, that's quite the list of injuries. I'm surprised he survived all that. He must be a tough customer if he can, wow, go through all that and still come out the other end still alive. Following the collision, Carrière de David made a claim for compensation to ICBC. The claim centered on his UMP coverage. Since the at-fault motorist, the driver of the Pontiac, had only basic third-party liability coverage, $200,000. ICBC settled the claim for a total payment of $665,356. I imagine that $665,000 must have included some payouts for the accident benefits portion of his policy as well, if the third party only had a limit of $200,000. Carrière de David sued Westland, claiming the broker he dealt with did not explain or recommend excess UMP, which would have increased his UMP coverage from 1 million to 2 million. He argued to the court that he'd understood he could get an extra 1 million worth of UMP by paying an additional premium amount of just $25. He would have bought it. Since he did not buy it, he presumed the broker must not have offered or explained it to him, as the appeal court characterized his argument. Just want to go back in this when it talks about UMP, uninsured motorist protection. Now, I'm not familiar with the uninsured motorist protection coverage in British Columbia. Here in Ontario, because what they're talking about is underinsured motorist protection, because the third party was insured. So uninsured motorist protection should not have kicked in if the third party is insured. Underinsured motorist protection, however, is a different coverage altogether. Now, I do not know if in British Columbia, if the UMP also includes underinsured motorist protection coverage. Here in Ontario, those are two separate coverages. Uninsured automobile coverage is part of the basic coverage under the Ontario Automobile Policy 1. Underinsured motorist protection, that is an endorsement called Ontario Policy Change Form 44R, Family Protection Coverage. So, like I said, I don't know if BC, they've combined those two facets together into the same one. But here in Ontario, it is two separate coverages, because the way they're describing it, where he says he can get an extra 1 million worth of UMP by paying an additional premium of $25, that really sounds like they're talking about underinsured motorist protection. So I know it might be splitting hairs for some of you out there, but just want to be clear, in some provinces, those are two separate coverages and you do not work the same. Here in Ontario, when you're talking about uninsured automobile, there are no options when it comes to that particular coverage. There is when it comes to underinsured motorists at OPCF 44R, but uninsured automobile, no, it's the same coverage for everybody in the province. Getting back to the article, the lower court found the broker had followed Westland's established procedure guided by a computer and advised about the purchase of excess UMP coverage of $2 million for a cost of $25 more. Carrière de David declined this option, the court found, following which the broker keyed N for no into Westland's computer system. Carrière de David later confirmed his choice to decline this optional coverage when he wrote his initials next to the words "no excess UMP purchased on this transaction" on the insurance contract. So he really doesn't have a whole pretty big leg to stand on at this point by claiming he wasn't explained when he initialed beside these statement on the application or on the form that no excess UMP purchased on this transaction. So, it would seem to a reasonable person that the broker must have explained it to him if he's willing to initial beside this particular statement, but that's just my opinion. If you feel differently, please let me know in the comments section. The lower court found the broker did not follow up with Carrière de David after he declined coverage. I do not find that Mr. Carrière de David asked the broker questions about excess UMP, or that she elaborated upon her standard explanation of UMP coverage that she habitually gave to clients, the lower court found. I also do not find the broker made any particular recommendation regarding whether Mr. Carrière de David should buy excess UMP or continue with his basic UMP coverage. Carrière de David appealed the decision, saying it was an error for the trial judge to conclude the broker fulfilled her duty as an insurance advisor, since she did not follow up with a recommendation for him to buy the excess UMP coverage. But in this case, the appeal court ruled it made a difference whether or not Carrière de David was familiar with the UMP insurance offered by Autoplan. Both the appeal court and the lower court cited that he had heard repeated explanations over the years of how excess UMP worked, and he had declined it each time, as the trial judge put it, and was paraphrased by the BC Appeal Court. Carrière de David was a long-standing customer of Westland's office who had been offered and declined excess UMP on multiple occasions and who did not indicate either particular interest or lack of understanding of this type of optional coverage. Thus, the appeal court rejected Kennedy DeVee's appeal against Westland. So, yeah, $25 in hindsight does not seem like a lot. Keep in mind when it comes to underinsured motorist protection coverage here in Ontario. Normally, the liability limit that you have for third-party liability is going to be the same as the liability limit under the OPCF 44R family protection endorsement. So this is why my particular brokerage, we always quote $2 million third-party liability. So they'd have the $2 million coverage on the underinsured motorist protection coverage of OPCF 44R. Keep in mind, there's no requirement anywhere that states that the two limits must be the same, because the two limits are separate. They do not, third-party liability, underinsured motorist protection coverage, the two limits are separate. They do not work the same. They are not meant for the same person. Third-party liability is for third parties. Underinsured motorist protection is for first parties or for the insured. So I'm not sure why insurance companies in Ontario make that a requirement that the two be the same, since the two coverages do not interact with each other, but we have to go with what the insurance companies, how they want to play it, so we have to go along with what they say. So but my particular brokerage, we always quote $2 million third-party liability. There are higher limits available with some insurance companies, or possibility of higher limits with a umbrella policy, excess liability policy, but we normally quote $2 million just so they have proper liability coverage at a minimum anyways, and also has that additional protection for OPCF 44R. So if this is something that concerns you now that you read about this particular case, take a look at your automobile insurance policy. It doesn't matter if we're talking about Ontario. Any of the provinces that have private insurance schemes, so any other province except Manitoba, Saskatchewan, and British Columbia, take a look on your and Quebec, sorry, because Quebec has a different system altogether as well. But any other province or territory I didn't mention, take a look at your policy, what it covers for that underinsured motorist protection, and don't skip out on it. I know $25 for this particular folk, for this or for the plaintiff, 25 bucks didn't seem like he should have balked, but a lot of people try and save wherever they can, and sometimes these additional coverages, that's the first place they look to save on their insurance. But yeah, definitely have a look. If you don't understand how it works in your particular province, contact your local broker agent and have them explain it to you. Quote that higher limit and see if you can really, find the cash to increase that limit. I know it seems, it's a bit of a hard sell to imagine yourself being in an automobile accident and having injuries in that automobile accident and it being serious enough that you're going to be suing another party because of them, and the other party being underinsured. There's a lot of, boxes that have to be ticked before that particular coverage, kicks in. But if you're ever in that situation and that coverage does kick in, you will be glad that you spent the money for that additional limit for the underinsured motorist protection. Our next story actually comes from the Northwest Territories. I don't get to talk about insurance in the territories much, but here we have a case. Liberty Mutual faces trial over bond and contract dispute in wind project. A court has held the insurable liable for damages. A high-stakes legal showdown over the Inuvik High Point Wind Project's access road now puts Liberty Mutual and contractor ONEC Construction on the hook for potential damages as the Supreme Court of the Northwest Territory orders a trial to quantify losses arising from unpaid invoices, bond disputes, and fractured construction contracts. Justice Annie, I'm not sure if it's Piche or Piche, ruled that ONEC and Liberty Mutual Insurance Company are liable to Northland for contractual damages, but said a trial is required to determine the amount. She also ordered ONEC and Liberty to pay Northland party and party costs in any event of the cause. ONEC and Liberty had originally taken the Northwest Territory NWT Energy to court, alleging Northland induced contract breaches, damaged equipment, and stole fuel. Pichet dismissed those claims, noting no evidence was filed. Northland responded with the counterclaim for unpaid expenses. Construction of the access road began in 2022, with Northland submitting monthly invoices to ONEC. By September that year, Northland issued a notice of default for unpaid invoices. On November 9th, 2022, ONEC instructed Northland to stop work due to its dispute with NWT Energy. Northland ended its contract in January 2023, citing outstanding payments. NWT Energy also terminated its contract with ONEC, and on February 10th, 2023, informed Northland it could make a claim under a Liberty bond. Northland submitted the claim on March 3rd, but Liberty denied it. ONEC claimed its claim in April 2023, and Northland filed its counterclaim in September. So for those of you who are not familiar, bonds and insurance are not the same thing, although often insurance companies will sell bonds. And we're not talking about investment bonds. These bonds that are issued by insurance companies, it's going to guarantee that there's normally two parties involved, besides the insurance company involved in this bond. So what the insurance company is doing by issuing a bond is guaranteeing that one party that's taking out the bond will meet its contractual obligations to a second party. So bonds are seen a lot in the construction industry. It's not the only type of bonds there are. Other industries also use bonds as well, but they're very common in the construction industry, as we see in this particular case. So with the construction industry, you have performance bonds, bid bonds, materials and labor bonds. Bid bonds normally submitted in some case with some construction bids that the project will commence. Performance bonds that the construction company will complete the task. Materials and labor bonds are there to ensure that laborers are paid, and materials that have been purchased from vendors, that they get paid as well. So it differs from insurance companies, or it differs from insurance. With insurance, we don't know who the other party is. We know who we're insuring, but we don't know who the third party is until there's an actual claim. And normally when it comes to proper liability insurance, is covering bodily injury and property damage, it's not really there to guarantee that the insured is going to be carrying out certain actions, meeting certain requirements. There is the possibility of adding a small amount to a liability policy for certain types of contractual obligations. It's very limited when it comes to a liability policy, but that's some of the ways that bonds and liability policies differ from each other. But once again, insurance companies normally are the ones who are issuing bonds. But bonds is not needed for every type of commercial venture, but liability insurance, whether it's commercial general liability, professional liability, that has a much more greater target audience, customer base for that type of policy as opposed to bonds. Continuing on with the article, Rob Adams, president of Northland and former president of Northland Operations at ONEC, from February 1st, 2021 to June 20th, 2022, essential to the case. ONEC argued his dual roles tied Northland to ONEC's termination by NWT Energy. Pichet found that Adams signed the contract in his capacity with ONEC. That does seem kind of odd that he's working for both Northland and ONEC, but okay. I guess it made sense at the time. Court documents stated that Northland's participation was needed to secure the contract as as it is a Gwichin-owned business, Gwich apostrophe IN, hopefully I'm pronouncing that right. And the involvement of Gwichin firms was important for obtaining the agreement. Invoicing disputes also arose. Northland billed flat rates rather than itemized costs, and Adams' timesheets lacked dates and hours. Onex CEO Dennis Weart testified Adams invoiced 14 to 16 hours per day from March to October 2022, including a vacation day exploring the Mackenzie River. Pichet ordered a trial to quantify damages. Background reporting showed Onex Nations Limited, responsible for Indigenous Partnership, listed false addresses in Inuvik and Yellowknife on its website as of May 12, 2022, with Adams identified as president. Pichet also ruled Northland must pay outstanding balances to NWT Energy, which owns the project, through NT Hydro, which wholly owned by the territorial government. So, yeah, bonds is definitely one of those facets of insurance. You'll have some brokers that specialize just doing bonds just because of the complex nature in establishing a bond contract with an insurance company. There are certain requirements that insurance companies will require, financial records and such, before they'll even consider offering you a bond contract. Liability insurance, no, not the same requirements. So that's why you'll have some brokers that specialize just in bonds. And our last case goes back to British Columbia regarding an accident and compensation for injuries suffered in an accident, and a recent tribunal ruling. BC Tribunal caps ICBC crash compensation under no-fault rules. The crash victim will receive a recalculated impairment payment. British Columbia's no-fault auto insurance system played a central role in a civil resolution tribunal ruling that denied further compensation to a van passenger injured in a 2021 crash, limiting the claim to a recalculated impairment payment from ICBC. The decision, issued July 29th by tribunal member Jeffrey Drozdiak, involved a single vehicle rollover near Toms Lake in August 26, 2021. A driver lost control of a van on gravel, causing the vehicle to roll. The passenger, identified by the tribunal as CRS, the initial CRS, was airlifted to Edmonton, underwent surgery at the University of Alberta, and later returned to Quesnel for several months of hospital recovery. The passenger suffered fractures to the left arm, collarbone, pelvis, sacroiliac joint, lumbar vertebrae, right rib, and 8 left ribs. ICBC previously paid $83,732.50 in permanent impairment compensation. CRS applied to the tribunal, arguing that the injuries were catastrophic and warranted higher compensation. ICBC argued that the injuries did not qualify as catastrophic impairment. The insurer also noted that the damages sought by the applicant were not available under the no-fault insurance system. British Columbia's Insurance Vehicle Act, effective May 1st, 2021, bars civil lawsuits for bodily injuries from motor vehicle crashes occurring after that date. I'm not sure if that's exactly accurate. British Columbia is not an absolute no-fault jurisdiction. I know in British Columbia you can sue for injuries you suffer in an automobile accident if the other party is convicted of certain criminal code convictions, such as impaired driving. I think also if your injuries are considered serious and permanent, they can also sue for pain and suffering in British Columbia. So maybe it was different between May 1st, 2021 and another time, but I don't recall a time in British Columbia where there wasn't some sort of circumstance where you can sue for your injuries in an automobile accident. If you have more information about this, please let me know. Please correct me so we can all be properly educated on British Columbia's system when it comes to suing. So there's only a couple of provinces in Ontario, in Canada, that you cannot sue for your injuries in an automobile accident. That is Quebec and Manitoba. I believe in Saskatchewan You may be barred from suing for injuries you suffered in an automobile accident in certain circumstances, but definitely Manitoba and Quebec are the two where it's absolutely barred under all circumstances. So other provinces, you can sue if you meet certain criteria, such as British Columbia and here in Ontario. In his ruling, Drozdiak ordered ICBC to recalculate the award, but ruled that CRS was not entitled to additional permanent impairment compensation. The decision noted that the applicant could reapply if post-traumatic stress disorder is found to be permanent or if other qualifying conditions arise. The tribunal adjusted certain impairment ratings. The rating for external internal hip rotation was raised from 3 to 5%. A 5% rating was applied for gait instability. ICBC had also assessed a 5% rating for loss of sexual function. I don't know if insurance companies in Ontario rate for loss of sexual function when determining compensation for an injury, but that could be something that's just unique to BC. I don't know about that. The tribunal directed ICBC to complete the recalculation and increase the payment within 14 days of the decision. So yeah, so there's a case when it comes to injuries and how the courts interpret compensation for that. So in all three of these cases, the reason I bring this up, because regardless of how long you've been in the insurance industry, how much you've studied, how much knowledge, technical knowledge you have of all the different types of insurance, wordings, exceptions, exclusions, in the end, it's up to the courts to make the final decision on how a particular coverage, exclusion, limitation is going to be applied. So that's why it's always good to keep an eye on court cases to get an idea of how it actually should be interpreted, how a particular coverage should apply, exclusion, condition. So it's, as a insurance professional, it's good to always keep up to date with these sort of things, so you can, as an intermediary, somebody who deals with the public, being able to properly advise my clients. But even if you work on the insurance company side, when coming up with new products or being prepared, knowing ahead of time how courts will react if you run into the same situation that a particular case is dealt with in the past. So always keep an eye out on court cases. It's always interesting, as well, to see how these court cases result in the different rulings by judges and how they interpret that as well. So that is it for me for today. I want to thank you for joining me. If you like what I do here, please leave a like on this video. Please leave a comment on any of the cases we spoke about today. Be sure to follow Insurance in Canada on X/Twitter. Reminder that the episodes for Insurance in Canada will be uploaded to Spotify as audio podcasts. And until next time, bye-bye.